Well, I mean, you mentioned the first then, which is mooting, and obviously this is the speed mooting podcast. So we run lots of competitions. We have our national speed mooting competition, and we also do advocacy competitions as well. And Mike, you've very generously given up your time on multiple occasions to judge at our competitions. Um, you've obviously seen this type of advocacy at the coalface then. Are there any sort of common mistakes that you see from students that take part in these competitions that you think can very easily be sort of tweaked and improved?
Yeah, I think there are two things that tend to stand out as quite common mistakes. One is being too script bound, and I think that's increasingly common with remote moots
Hmm.
because there's more of a temptation to have half the screen with your script on it and the other half of the screen with the camera on it, and you sort of
Yeah.
flick between the two. That can be quite effective because, of course, if you've got a script, then you know you're going to hit all the points that you need to say. But where you become derailed is the moment a judge asks you a question and pulls you away from your script. Then, when you try and go back to it, you'll find that you've lost your place and you've lost your flow. And so, a lot of people use scripts as a bit of a comfort blanket, but it's really, really important to try and get away from that as soon as you can, even if it's a question of going from a full verbatim script of what you want to say initially just to paragraphs maybe that you feel you need to get absolutely right, and then from there sentences, and then from there individual words or phrases that are going to trigger what you need to say in the course of the moot. It doesn't have to be a binary, I either script everything or I just turn up and wing it as I go. And there's plenty of ways of working from one to the other, but that's quite a common problem, that people are just too script bound, and it does them a disservice. Because actually, what you'll often find, and I ask a lot of questions as a moot judge because it's the best way of testing advocates,
Hmm.
and often what I find is that when you ask a question, you get a really good answer back, and there's no way it could have been scripted.
Yeah.
So the advocates could actually do it without a script, but they don't have the confidence. So that's the first thing. The second thing that I find is quite a common mistake, which can really derail your mooting very, very badly, is if you try and go beyond the information that you've been given in your brief and in your question. So sometimes I will find advocates that will try and bring in additional facts that aren't part of the fact pattern that they've been given. They might even try and bring in additional evidence to a moot, by relying on documents that aren't part of the moot problem, and things like that. And it does enable them to make what is on some view, a clever or intricate submission. But quite often you find that it just derails the moot completely because you're actually spending a very limited time talking about something that's outside of the scope of the moot. And I think one of the things to bear in mind if you are a mooter or an aspiring mooter is to remember that it is still an artificial process. So you are given uh, tram lines within which to work.
Yeah.
So although it is sometimes possible to bring other stuff in, if you haven't been given it, then it's just to keep the focus on what you should be doing.
Yeah. Keep it simple. I mean, that's exactly what we do with our mooting competitions. There's different ones out there, but with ours, there's no drafting and no research involved. So everything's supplied to the mooters, all the legislation, all the case law, the skeleton arguments are even pre-drafted. So there's nothing else that you can bring in. It's all there. So yeah, as you say, by trying to add anything else in, it's just sort of convoluting the issues. Keep it simple and show that you can use the material that's before you to present the most persuasive argument. It's interesting that you mentioned judicial intervention and that you ask lots of questions to sort of test the mooter. Um, one of the pieces of advice that I give quite regularly at the advocacy club is to really focus on judicial intervention. Think about where the weaknesses in your case lie, where are the strengths in your opponent's case, and you can bet your bottom dollar that is going to be the focus of the questions. So think about those beforehand, and then you know roughly which questions you won't know the specific form of the question, but you'll get a good idea of the question, and you're ready that when the question comes, you can deliver an intelligent answer. So
Yeah,
yeah.
absolutely. Absolutely. I mean, it's a little bit like a job interview in the sense that you can look at your own CV and you can kind of see where weaknesses might be or where questions might come. And you might then have in your mind a sort of outline of a possible answer to a number of different questions that might arise from a particular point. And then when you are asked the specific question, you can just add the specific detail. And I think mooting is quite similar to that, in the sense that you can have an idea as to where some of the questions might come. Absolutely.
Perfect.